During that conversation, we just talked generically about proceeding with the sentencing. I don't see that there's any reason not to proceed based on that conversation. Is that accurate, Mr. Stossen?
Correct, Your Honor.
Mr. Thomason, is that accurate?
That is accurate, Your Honor.
All right, we did have a question, there was a question asked of me early this morning through my staff about somebody appearing via Zoom, although I'm unsure as to who that is. Mr. Thomason, did you confirm with your staff who it was that wanted to appear by Zoom?
Yes, it was, I believe, the victims wanted to appear by Zoom, but they did provide a victim impact statement that has already been provided to Mr. Stosage, and we would just like to submit that to the court.
Please, I will need to review that. All right, so we do have Zoom set up. I will ask that the individuals that are attending by Zoom, I will note they are the representative of the victims. They are attending by permission. This is not a hearing that is being broadcast, but I am allowing the victims to at least attend via Zoom. But I need to make sure that they understand that they need to keep their camera off and they need to stay muted. They should be able to hear and observe the hearings, but that would be the extent of it. I have been handed a victim statement. I just need to read it for just a couple of minutes. All right, and just confirming, Mr. Stosage, you had an opportunity to review that victim statement, did you not?
Your Honor, I guess I need to go on the record on this. In answer to the court's question, I would just refer to page 2 of the pre-sentence investigation report, indicating that I don't know who wrote this victim statement because it's not doesn't have the author's reference on it. It generally refers to
The
the
relationship
victim
between...
and the parent, that is the parents. The pre-sentence investigation indicates that no victim impact statement was submitted for consideration, of course, and therefore there was not one attached to the pre-sentence investigation report. So, and there are some assertions, I think some inferences that the family has taken from the circumstances that are stated in rather critical phrasing in the victim impact statement, that had I known, we would be able to make a record of refutation of some of the assertions made. So I guess I understand under the U.S. or the Idaho Constitution, this court does consider and these folks have the right to give input for sentencing. I just think that it should have been provided ahead of time so we would have the opportunity to provide specific response to some of the allegations made in the statement that would be critical under the consideration of Idaho Code 19-2521. So whether I don't know what the court intends to do with that. You've read it. It's not like you're a jury that we have to make evidentiary rulings about. I think the court can keep it in context, and I don't believe for this setting it's necessary for me to ask the court to strike it, but I certainly would indicate that there is some information in there that would have been good to know ahead of time, but we'd ask the court just to keep that in mind as the court considers the statement.
All right, thank you. Mr. Thompson, any comment in response?
The only thing I would say, Your Honor, I think the only difference between this and then having an impact statement made live in court is this one is just essentially written down, and we know essentially what it says. Had the victim come in and personally made a statement, the victim's family, I'm sure what was said would be probably similar to this document that we're holding. So I don't know if it would make a lot of difference either way. This seems to be the feelings of the victim and the victim's family, and so I don't think it would deviate much from what's written down, or whether that would whether that be spoken out of the victim's mouth.
All right, I appreciate that. All right. I will note for the record, having reviewed that, I will take it into consideration. It is obviously better practice to at least have the author's name, but I will also note that I will take it into context with respect to the other 161 pages that were provided as part of the pre-sentence investigative report for purposes of moving forward with respect to sentencing. So, all right, any other preliminary matters, Mr. Stosich?
No, Your Honor.
We are here for sentencing today of Mr. Stahn. Is it the intention to move forward with sentencing, Mr. Stosich?
Your Honor, this matter was submitted to the court as part of a binding plea agreement. I think in order to respond to that question, I would ask the court, after reviewing the record of this matter, including as the court indicated, now 162 pages of the pre-sentence investigation, including the victim's statement, whether or not, and understanding the plea agreement and the premise of this case, the way the case came about, the recommendations in the pre-sentence investigation report, we would like to be advised whether or not the court intends to be bound by the plea agreement. And I would indicate, Your Honor, that we're not ignorant of the nature of the crime. The sentiments expressed in the victim statement are certainly sentiments that we know exist, and know that a binding plea agreement, when you consider State v. Toohill and Idaho Code 19-2521, the sentencing criteria for the court to consider, it's very unusual even for me, Your Honor, in my practice to submit a binding plea agreement for the court. But the reason we do that is so we can be advised as we appear for sentencing whether or not the court is accepting the plea agreement and intending to be bound. I'm not sure this is one of those cases where we include the court as a party to the plea agreement as a contract, but it certainly is an advisory situation that we know whether or not as the final arbiter in your discretion, if you intend to accept the plea agreement and the part of the plea agreement that binds the court, that would certainly cause us to either go forward with sentencing today or ask the court to recess today to determine what we should do next.
Understood. I will note that the plea agreement that was filed, there were some recommendations placed in there with respect to the things that Mr. Stosich referenced. The would be paragraph 3 of the plea agreement, where it's indicated that at sentencing, both the state and the defendant will jointly recommend I place the defendant on probation. The term to be determined by me, but the parties intend, based on that plea agreement, to bind the court with respect to a term of probation rather than imposition of immediate sentence. I will note the remainder of of any sentence that might be imposed is still left to my discretion, and I am not bound by that. So it is with respect to whether or not I place Mr. Stahn on a period of probation or impose a sentence.
And we agree with that interpretation of the binding portion of the plea agreement.
Thank you. Mr. Thomason, does the state also agree with my interpretation of that binding portion?
Yes, Your Honor.
And I don't know if the court was going to reflect or remark upon this, Your Honor. I think we covered this in the sentencing or the change of plea hearing. This case actually went to mediation after the psychosexual evaluation was prepared. And so, and the mediation was conducted by a senior district judge with the same experience as Your Honor. And we arrived at the plea agreement through that mediation with the input of all the parties, including, I believe, the Steeds. So it wasn't without a significant forethought that we presented this binding plea agreement to the court.
And I was going to cover that, and since you brought it up, it was my understanding, we did cover it at the change of plea, that this resolution was reached through the mediation process, and that the victims had opportunity to participate in that mediation process. With that factor, as well as all of the information that I read with respect to the pre-sentence investigation, it is my conclusion that I will be bound by that provision in the plea agreement. So Mr. Stahn, you know in advance that I will be placing you on a period of probation. There are other terms of your sentencing that I will go through. And I certainly will outline for the parties the reasons why I agree to be bound by that provision for probation rather than immediate imposition. But I am intending to be bound at this point, Mr. Sosage. So at that, are we proceeding with sentencing?
Yes.
All right. Mr. Stahn, before I turn it over to the parties for comment and recommendation, and Mr. Stosage, I'm going to just chide you just a little bit. I have a remote reporter who every time you touch the microphone, it creates havoc in her earphones.
And she's told me that before, Your Honor.
She has scolded all of us at one point or another. And you know what? We had a pretty good track record until today. So,
Well,
anyway, if you could refrain from doing that, it also then may affect her ability to actually get an accurate record. And I know it's habit for a lot of us to adjust the mics, but
thank you, Your Honor.
all right. Mr. Stahn, I do just want to go through the procedure of your case a little bit, the history. You originally appeared before me May 22nd, 2023 at an arraignment, at which time you were advised the state had charged you with the crime of sexual abuse or exploitation of a vulnerable adult. You pled not guilty at that time. However, following the mediation that your attorney and I just talked about, you appeared back in front of me October 23 of 2023, and pursuant to that plea agreement, you pled guilty to sexual abuse or exploitation of a vulnerable adult. In exchange for that, the state agreed that it would recommend I place you on probation. It also agreed that it would recommend a specific underlying sentence of a 3-year determinate period of time, followed by a 9-year indeterminate period of time. The state reserved its right to argue any other factors or criteria of sentencing. You yourself agreed not only to plead guilty to that charge, but you reserved your right to argue what an appropriate underlying sentence should be. As indicated previously, a portion of that, the fact that the parties will be asking I place you on probation, was intended to be binding on this court, and having reviewed all factors, I will be bound by that provision, reserving my discretion with respect to other items of your sentencing. Following your plea of guilty, I ordered a pre-sentence investigation be prepared. I also ordered that a psychosexual evaluation be prepared. You had already had a psychosexual evaluation, and you submitted that as part of your pre-sentence investigation packet. All of that information, including character reference letters that were provided by you and your counsel, as well as the victim statement that we've discussed today, was filed December 15 of 2023. Mr. Stahn, did you have an opportunity to review that document? the entire pre-sentence investigation report? Did you review that
Yes, Your Honor.
document?
Yes, Your Honor.
Mr. Stosage, anything in there that needs to be corrected or clarified? And I will note for the record that it appeared to me that some of the report contained notes from Mr. Stahn, so it was submitted twice, but it seemed like it was then sent in with notes about questions Mr. Stahn had about some statements or some things he felt were inaccurate. So I want the parties to be very well aware that that's how I read some of those pages. Aside from all of that, or if we need to go into detail, is there anything that needs to be corrected or clarified?
It's interesting that the court would raise that when I read the pre-sentence report with the attachment and saw those writings. As a trial lawyer, my meter went off about moving to exclude, but in a sentencing phase, I think it's entirely appropriate that those comments and those edits were included in the PSI and actually probably streamlined the process a little bit. So no, Your Honor.
All right, I appreciate that. Any objection to me then relying on the pre-sentence investigation as provided to me for purposes of sentencing?
No, Your Honor.
Mr. Stahn, is it your intention to still stand by the guilty plea you previously entered?
Yes, Your Honor.
All right. Mr. Stosage, are there any witnesses for the defendant?
No.
Mr. Thomason, other than the victim impact statement you provided to me today, are there any witnesses for the state?
No, Your Honor.
All right, having said that, Mr. Stosage, I'm going to turn it to you at this point for comment, recommendation. Please stay seated so that we get an accurate record.
Thank you, Your Honor. I appreciate this time, and I feel that it's a privilege to have represented Mr. Stahn in this matter, and his confidence in the court and in the prosecutor's office and his family and me to be here today. Your Honor, as the court notes, and I'm making these comments with the knowledge that the court's going to accept the recommendation of probation, but I think it's important, Your Honor, to kind of do more than just make some brief comments about 1925-21 analysis and so forth. This case came forward as part of a self-disclosure that Mr. Stahn made in the attempt to improve himself. I think at the time, and which he hoped would consequently improve the quality of his life and relationships. And I think that attempt came as a result that Mr. Stahn has been made aware of over the course of the last maybe 10 years or so. And I could be out of context a little bit on timing, but there were a lot of things going on in Bob's life that he was unhappy with, and he was trying to address through counseling and through working through things personally and with his wife at the time. Resulted in this disclosure, which he felt was important and still does, to his efforts to improve himself as a person and as a partner and as a father, a grandfather. And that had to do with his feelings of depression, his clinical depression, and how it expressed itself. One of the ways that depression expressed itself was through sexual behaviors, which included the crime. And Your Honor, I have known Bob for, I want to say, at least 25 years. And interestingly enough, our paths kind of crossed almost 50 years ago, as we both worked as missionaries in the same geographical place in the world. And so our history is close together. And some 20 years ago, and before that, Bob was involved in court services and as part of the drug court teams and so forth. As a service provider, we kind of got to know each other then, and then for the past 25 years, there have been occasions when we have had both professional and personal associations. So I've known Bob for a long time, and nobody could have been more appreciative of Bob's attempts to address these issues in his life, or these deficits in his character, than me when this case came forward and Bob asked me to represent him. As the court has a flavor from all of the support letters of what kind of person Bob has been in some ways. And I think that a lot of those people had no idea, as expressed in the letters, that there was a side of Bob that Bob knew he had to correct. And that included this victimization of JS. I was grateful that Bob took my advice and went through the psychosexual evaluation with Dr. Hatzenbuehler. And I'm sure it was an experience for Dr. Hatzenbuehler to do a psychosexual evaluation on a mental health care provider with great experience, and I appreciate the recommendations that were made in the pre-sentence or the psychosexual evaluation. During the course of this case, it's been clear to me that Bob wants nothing more than to stay crime-free. That Bob wants nothing more than to experience the consequences, the actual legal consequences of the crime. Now, there have been personal consequences to this crime being exposed. There have been family consequences to this crime being exposed. And I actually think that the victim impact statement expresses that quite well when it's commented that there have been families changed, including Bob's family, because of what Bob did and what Bob disclosed. As I've gone through the mitigation and aggravation factors, of course, the aggravating factors are factors that we cannot change. That I don't know if Bob contemplated the harm it might cause, but certainly it causes harm. The crime caused harm, as expressed in the victim's statement. I do know that Bob has engaged in behavior modification that is manifesting itself in positive ways now. And I think that probably was accelerated by the fact that Bob has gone through this criminal justice experience. Bob has spent some significant number of days in jail, and I would defer to the calculation that the Sheriff's Department can provide to the court as to the exact number of days. I don't know the exact number of days. Bob expressed a number of days to me, but we would defer to the record on that. Your Honor, it's only responsible for me as Bob's attorney to advocate the mitigating parts of this case, and that is that Bob is amenable to express retribution in any way the court determines is appropriate, as far as punishments in this case, or judgments, or whatever. Bob seeks to suffer the consequences as part of his correction. Bob's a religious individual who understands the process of moral forgiveness and moral repentance, or moral abandonment of behaviors, of exploitative behaviors, as part of his consequences, and subscribes to that, and is ready to pay that. We are very grateful that the court in this type of situation accepted the plea agreement and agreed to be bound to probation. That's not an easy thing to ask a judge in these kinds of cases. It's a very difficult thing for the court to countenance, and we appreciate that. Because we believe that probation will do one thing and one thing only, Your Honor. It will send a signal to everybody, whether Bob is true to the fact that he accepts the consequences of his acts. Part of that acceptance is abandoning the behavior. And so there'll be a period of time that Bob will have without bars control in his behavior to determine whether these changes these improvements in construction in his character and his actions is a long-term correction or a short-term correction. It's simple. We believe, I'm going to advocate under 19-2604 that as part of your 2521 analysis, Your Honor, it wouldn't be without justification to grant a withheld judgment in this case. It's significant to me, and I'm not sure it's as significant to to our community, to people who don't understand what a withheld judgment is, and to victims and even investigators, that a withheld judgment is simply a period of time where Mr. Stahn will not have a sentence. He'll be on probation for whatever the term of years the court deems appropriate, but he won't have a sentence. And the end game is that if Mr. Stahn successfully completes the experiences, the orders, and the obligations under probation, he would be have the advantage of having this matter taken off his record as a conviction. Now, that relief is no different, Your Honor, than 19-2604 relief. That would be available whether or not the court imposes a sentence today. I think the significant thing about the court considering a withheld judgment is that without a sentence, and in other words, without the court saying, I determine that there's an appropriate determinate term today, knowing what I know about Bob today, having Bob been under my jurisdiction for the past 7 months, what I know about him today, I determined that this determinate period of time and indeterminate period of time is an appropriate sentence to impose, and I'm suspending that. Well, if Mr. Stahn does not persist and maintain this attitude of correction and does have failures to follow the court's specific orders of probation, then perhaps the court would have a different determinate period and indeterminate period of time if there is a probation violation, which may be different than what the court would impose today, knowing what the court knows about him. So it's not without deep thought that I make this recommendation of a withheld judgment to the court, knowing that it could actually end up in a more severe sentence than the state might recommend today or the court might impose today, if Mr. Stahn proves to you that he cannot follow your orders. I feel that it is a responsible recommendation because the end result is the same as if Mr. Stahn had a sentence imposed today that successfully completes probation. He would still be eligible for 2604 relief, which is the relief of a withheld judgment effectively. So, Your Honor, the effect of the withheld judgment would not change his necessity to register as a sex offender. It would not change his necessity to follow every probation order of this court. It is merely a way for Mr. Stahn to understand that in the end he gets certain relief, and if he doesn't live probation, the outcome could be very different, Your Honor. So I'm not asking for that lightly or irresponsibly, Your Honor, but I do think with his lack of prior record, when you consider the qualifications of an individual for a withheld judgment, a one-time advantage in an individual's life, then I think that Mr. Stahn otherwise qualifies, except for the very seriousness of this crime, the level of harm, and the violation of trust. It probably sets it apart from other cases where we consider withheld judgment. But in any event, Your Honor, I think that's appropriate. As far as the term of years, I would remind the court that now Mr. Stahn is 65 years of age, just turned 65. He is, at this point, self-employed. He no longer works in the counseling industry or profession. He's self-employed. He's involved, and he's established a place to live. He's gone through a divorce. He has strong relationships, as the court has noted from the attachments to the PSI. He's maintained relationships with his his children. The nature of the crime, I think, only asks the court to, if the court is going to restrict associations of Mr. Stahn, it should not include his grandchildren, children, or other minors. This is not a minor preferential or at-risk population case. We think it would be appropriate for the court to enter a general no contact order for vulnerable adults, and that would be the extent of any contact restrictions that the court might impose. So, Your Honor, I recommend that the court, considering Mr. Stahn's age, that the court enter a period of probation for 10 years, grant a withheld judgment in this case, and we would defer to the court as far as other conditions. If the court is in, well, and if the court does impose a sentence of years, we would ask the court to grant credit for time served for Mr. Stahn. Thank you.
Thank you, Mr. Stosich. Mr. Thomason, comment, recommendation of the state?
Thank you, Your Honor. This is a somewhat unique case, given the self-disclosure from the defendant, Mr. Stahn. Without that, I think that no one would have ever known. So I think that's there's some uniqueness in that particular factor in and of itself. However, with that being said, Mr. Stahn was a caregiver for the victim for a number of years, and as a caregiver, there comes with that trust from the family members who they are entrusting on someone like Mr. Stahn to provide that care to their loved one, and that in this case, that trust, of course, has been violated. This is a victim with severe disabilities, someone who's nonverbal, and has significant deficits. And the defendant had taken advantage of the victim's disability here in this case, and violated the trust of this victim. Therefore, with that being said, having reviewed the psychosexual evaluation and the PSI, the defendant's LSI score is very low. It's an 8, very low risk to reoffend. The state does require that, as part of the plea agreement, the state is jointly recommending a sentence of 3 years fixed and 9 years indeterminate, or a unified sentence of 12 years, and jointly recommending probation. This was a plea agreement, to my understanding. I was not involved in discussions between the parties in this, but my understanding is the victims were, as far as another member representing the state, and that this was the agreement that the parties had come to during mediation. And so I think all these factors were taken into place. The defendant had no prior criminal history, no prior sex offenses. This was a self-disclosed admission to this particular crime. And I think with all that being said, I think that's how the parties arrived at this agreement. Defendant will be required to register as a sex offender. And so the state would be also asking that the defendant engage in sex offender treatment as part of his probation, and that he also serve a period of local jail time at the court's discretion. And as far as a withheld judgment goes, the state would be objecting to that. Basically, just because the nature of the crime, I think the risk to the community outweighs the importance the defendant might feel to him or his situation. I think this is important for the community to be aware of in the future. If deciding, especially given Mr. Stahn's line of work. So that would be the state's recommendations, Your Honor. And with that, I will submit.
Thank you, Mr. Thompson. Mr. Stahn, you have a right to make your own statement and address me directly. You do not have to make any statement at all. There's no requirement that you make a statement. And this court takes no negative meaning or inference from any defendant that chooses to remain silent at this stage of the process. But if you want to make a statement, now is your opportunity, and I would ask you to just make sure that you speak clearly so that we get an accurate record.
Thank you, Your Honor. I'm grateful that I have this step in the process of trying to make things right. So I'm grateful for that opportunity. I am regretful, sorry, sad for poor choices that I've made that have negatively impacted others. I am developing more and more appreciation for the impact that I've had on others and have more empathy for them. I am learning to deal better with the issues that underlie my poor choices, and I am learning more about myself, and I am grateful for that opportunity to be improving and knowing more about myself. I now, because of the most recent time frame and effort that I have been able to identify more character weaknesses or imperfections or defects that I have, that I am working on addressing and trying to improve that as well. So I'm grateful for those opportunities to know myself better and to improve. I certainly want to own my responsibility in the behavior that I have exhibited and the crime that I committed. I in no way want to foist that off onto anybody else or try to blame. I know that's mine, and I own that. And I am grateful to have this step in the process of trying to make things right, so that I can be moving ahead and progressing in that way. And once I am finished with probation, my intent is to continue to work on improving myself and to be a healthier human being in many different aspects of my life. But that's my intent. I just wanted to most of all express my gratitude for the process and for an opportunity to be making corrections and to making right many of the things that I've made wrong. Thank you.
All right. Mr. Stahn, are you fully satisfied with the representation Mr. Stosich has provided through this matter?
Yes, Your Honor.
Mr. Stosich, any legal reason I should not impose sentence today?
No.
And with that, Mr. Stahn, based on your previous plea of guilty, it is the judgment of this court that you are guilty of sexual abuse or exploitation of a vulnerable adult not amounting to lewd conduct in violation of Idaho Code 18-1505 B1C. In preparation of today, as previously indicated, I have looked at the entirety of your file, and that includes, but isn't necessarily limited to, the pre-sentence investigation report that was filed in this case. And in preparing for sentencing today, as well as any other sentencing, I must keep in mind the objectives that have been outlined by the Idaho Supreme Court for sentencing. Those objectives are punishment, rehabilitation, protection of society, and deterrence for you and others. I also have to look at the factors that are contained in Idaho Code 19-2521, which your attorney has referenced several times during his comments. And essentially, those are factors as to why a court would or would not place someone on probation instead of imposing a sentence. Keeping all of those factors in mind, I have already advised you that I will be bound by the terms regarding probation. And while that decision is never easy for a judge, regardless of the crime, it is particularly difficult and sometimes tricky with respect to these types of crimes as to why a court would place someone on probation. But I will try and outline for the parties the reasons and the factors that this court believed were most important to me, and why I'm going to give you the opportunity at probation. I will note that you're 65 years of age. As indicated by the prosecutor, your LSI score is 8, and let me explain what that is. The LSI is an actuarial table based up of 8 different categories. That score is based on how you answer various questions with respect to your life inside of those categories. And I'm sure as a counselor you understand the significance of actuarial tables like this. The importance for the court, the importance for the Idaho Department of Corrections and probation officers with respect to that number, and this is one factor that went into my decision, is the higher that number goes, the more likely it is an individual will commit another crime in the future. The lower the number, the less likely. You have an 8, which sits on the low scale. That tells the court, or no guarantee, but statistically, it is less likely that you would commit a crime. I will also note that aside from this charge, you have no criminal history at all. That includes no juvenile record, no misdemeanor record, nor any other felonies. The most aggravating aspect of this case is, or for this court, has to do with your victims. They were disabled as adults, nonverbal, autistic. You were placed in a trust position. We have heard that already today. You significantly violated that trust position because you took advantage of an opportunity when you had an individual that was unable to intervene on their own behalf. There are any number of mitigating factors, again, some of which have been pointed out by counsel. I think one of the more significant mitigating factors is your full disclosure and your self-disclosure. But for that disclosure, we may not be here today. Now, I'm sure there's a part of your brain that says, well, maybe that would have been better if I'd have just kept my mouth shut. It wouldn't be better for society. And likely, Mr. Stahn, you may have continued the activities. Don't know that, but you might have had other opportunities, and that might have been detrimental to others. So I do have to take into consideration as a significant mitigating factor that you yourself self-disclosed this. And it was not you providing information after somebody questioned some activity of yours. You have taken full responsibility for your actions all along. Interestingly enough, most of your actions involved exploitation and voyeurism. There are any number of categories of sex-related offenses. A significant portion of those involve individuals making physical contact with victims on a significant scale. From what I read in the reports, from what I read in the PSE, your physical contact with the victims was rather limited, and most of your deviant behavior was related to taking opportunities to view the victims in stages of undress or to place them in positions where you could view their bodies to your gratification. You have no drug or alcohol use in your past. You have a high education level. You were, in fact, in the military. You served honorably and were discharged honorably. You have significant employable skills. You were, in fact, self-employed as a counselor, as indicated by your attorney. You were involved in the court system as a counselor. All of those are mitigating factors. I will also note that another mitigating factor this court took into consideration is that these events took place give me a moment. In 2021. So while it doesn't mean they were less harmful, what that tells the court is that we have a period of time where there were no activities of yours. We have a period of time since the activities occurred that we've not had any additional problems. Now, I know that society and the world wonders if you self-disclose about these, what else have you done that you're not telling us? And I understand that that may be a concern for society. This court relies heavily in these types of cases on the psychosexual evaluation, which also includes a full disclosure polygraph. Now, interesting that courts don't allow polygraph results for purposes of determining guilt or innocence of an underlying crime. But in these particular crimes, once a person is entered a plea of guilty or they've been found guilty and they submit to a polygraph, this court places significant weight on the responses. And I want to take a moment to indicate why that is important to me for purposes of whether you have been honest and truthful and forthcoming with your full disclosure. You were, during that psychosexual evaluation, there is a polygraph given as indicated, and there I am going to generically summarize these. You were asked a generic question other than the victims listed. Were there additional significant illegal sexual touching with them that you are hiding? Based on your response, there was no significant response. What that means is that the polygrapher and the machines indicated you were being honest. So that tells the court that you did in fact fully disclose. It asks with respect to family members if you've had problems. Again, no significant response on your answer, which tells this court you were truthful with your disclosures. So That was a significant factor for me, Mr. Stahn. Your attorney and the state's attorney could tell you that there probably have been any number of individuals who go through that testing, and there is significant response with respect to them not necessarily being truthful in their disclosures. So I've placed significant weight on that in making my determination. Other factors that went into this consideration as contained, as indicated, I weigh heavily the psychosexual evaluation that are provided in these. Based on all of the testing that you had in the psychosexual evaluation, you actually end up at a below average risk to reoffend. This court, I have to take into consideration the protection of society. The protection of society factor for this court is what is the likelihood that you will do this again? And that's that risk factor. You're below average. Can anyone say that you will never be a risk? No. That's not practical, nor do I believe you expect that. I don't expect that. I'm looking at whether you are above or below average. Based on your testing, you're below average for risk factor in the future. You have significant protective factors that are built around you. That helps drive that risk down. They include your age, no criminal history, and the fact that you have been able to establish extended long-term relationships. Those tests do show that there is a need to address your behavior, and I don't believe you're saying there is not that need, because the fear, if it is not addressed, that there might be opportunities for you and you might again find yourself before this court. But the psychosexual evaluator did indicate that she believes that these things can be addressed through sex offender treatment programming. It's also noted that your potential risk to reoffend falls within the voyeuristic or exhibitionistic category rather than contact category, which is consistent with the actions that led you to this court. That is a factor that actually drives the risk down. It's also unlikely that you'll be presented with the opportunities that you had in the past. There is data, Mr. Stahn, that this court has to also review when it's imposing sentences for these types of categories with respect to overall what is accomplished if I send you to prison or I place you on probation. The evaluations suggest that you're amenable to treatment, and it's actually better that you be placed in the community so long as you attend to that treatment. The reason for that is that while it may not be popular with society to place you in the community, statistics show that if somebody with this type of crime and your type of background is placed in the prison system from a punishment perspective, when you finish that prison term, you're actually more dangerous to society than you are right now. You actually learn criminal behaviors while you're in the prison system. So when you are released, there's the possibility that you have not fully addressed the deviant sexual behavior that brought you to my court, so you still have to address those, and you've learned other criminal behaviors that could potentially be out of control. And so while not popular, there are certain circumstances, yours included, where probation is actually in society's best interest because we can address the underlying problems better and actually protect you and others, so long as you comply with the treatment. All of those factors being said, they all weighed into my decision as to whether or not I would accept and be bound by the purpose of the plea agreement and be bound by the probation request. And because of those factors and everything that I learned in review today, that is the reason why I am being bound by that. I am not going to grant the motion for withheld judgment, Mr. Stahn. I understand the argument made by Mr. Stosage. There is some merit to that argument to give this court a clean slate in case you don't successfully complete probation, that I could then impose a more significant term of prison than I would impose today. But I also believe the counter to that is the message that that sends, maybe to you, but maybe to others, that you, quote unquote, got off of the charge. Now, there are still opportunities, as your attorney explained, if you successfully complete the probation. The relief that's available to you under Idaho Code 192604 may still be available to you, and the end result would be the same. But for today's purposes, I think it's important that you understand there is a prison sentence that is out there if you fail to comply with the terms of your probation, and that prison sentence would be imposed, so you understand the consequences up front and what that looks like. With all those factors in mind, it is the judgment of this court that you be sentenced to the custody of the Idaho Department of Corrections as followed, for a minimum determinate period of time of 4 years, followed by an indeterminate period of time of 9 years, for a unified sentence of 13 years. Now, I did go a little higher than what the state recommended, and the reason for that is all the aggravating factors that went into this. Because if in fact you don't learn to address your behaviors, if you don't take probation seriously, then all the aggravating factors drove this court to a higher determinate period of time that you will in fact serve with those probation violations. As indicated before, I am going to suspend the execution of that sentence and place you on probation with the Idaho Department of Probation and Parole for a period of 10 years. While you're on probation, you will be subject to the standard terms of probation, but you will also be subject to the special terms of probation as a sex offender. They do have a list of those, and they include restricted access to individuals. I am going to modify that to not include your grandchildren, so long as their parents want you to spend time with them, and so long as your treatment provider does not believe that's detrimental to you or the children. Your history does not suggest that that is your problem area, but I'm leaving it up to the family members to decide if they want to spend time with you, and I'm leaving it up to your treatment provider to determine whether that's in your best interest. I am going to extend, if one has already been issued, and if one has not been issued, I am going to extend a no contact order with the victims of this crime, and that will continue for the entirety of the term of probation. I'll also advise you that the victims do have the opportunity to extend that longer if they want to when it gets to that 10-year period, but that will involve them filing a proactive motion to extend it. I am going to order that you serve local incarceration in the amount of 60 days. I will give you credit for the time you have served. I will leave it up to the Bonneville County Sheriff to calculate that time, Mr. Stahn, but my numbers indicate that you served about 26 days. But those are my numbers. I'm leaving it up to the sheriff. They have an accurate number. If my numbers are accurate, that would leave 34 days that needs to be served with the Bonneville County Sheriff. I will order community service in the amount of 100 hours. there is a $60 fee for the workers' compensation that you'll have to pay as part of that. Fine in the amount of $1,500 plus court costs. I will order a civil penalty under 1953-07 in the amount of $1,500. I am going to leave restitution open. I did not see that there was a motion for restitution, Mr. Stahn. I don't know if there is any restitution. I'm leaving it open for 30 days to allow the state to review its file, and I am taking into consideration the fact that Mr. Thomason was not the initial attorney on this case. This resolution was reached while it was under somebody else who has since left the office. And so I understand Mr. Thomason's position of he may or may not have all of the details of this case. That being the case, I'm going to leave it open for 30 days. If nothing is filed, then there won't be any restitution. You will be required to register as a sex offender pursuant to Idaho Code 188307. That registration is for life, Mr. Stahn. There are opportunities for you to petition to be removed from that, but as we sit here today, that is a lifetime registration. Your attorney can discuss it with you in greater detail. We'll also order that you serve an additional 180 days in local incarceration to be held at my discretion. What that means is if you violate any term of probation, you could be ordered to serve one or all of those days as a punishment or penalty for violating the terms of probation. If you have no probationary term violation, then you won't have to serve any of those days. I will order that you fully participate in and complete sex offender treatment. The particulars to be outlined by a treatment provider. And again, you will be relying on that treatment provider with respect to whether it's in your best interest that you have contact with your particular grandchildren. Mr. Stosich, anything about my sentence that I need to correct, clarify, or I failed to address?
Not that I can think of, Your Honor.
Mr. Thomason?
I don't think so, Your Honor.
Mr. Stahn, again, you will be required to provide a DNA sample. Anybody who is convicted of a felony in the state of Idaho by statute is required to provide that DNA sample. You will work with a probation officer to provide that. Do you understand that?
Yes, Your Honor.
Mr. Stahn, do you have any questions about the sentence I've imposed today?
Yes, I do.
Go ahead.
When you mentioned that I can have contact with my grandchildren if that's okay with their parents, what does that mean about me going to places in the community where there are minors? Does that, how is that affected?
Your sex offender treatment probation terms will have restrictions on your attendance in the community where minors are. That is part of the terms of sex offense treatment. What I suggest to you is that if you make a motion to this court in the future to allow you to go to some community areas where there are minor children, I will be relying on your treatment provider to advise me whether they believe that that is dangerous to the community or not. The reality of it is your victims were adults, and yet their mental capacity was that of a minor. So it is a unique category of victim, Mr. Stahn, and I am going to have to rely on your provider to tell me whether or not those restrictions need to stay in place or whether they need to be removed. As of today, they will be in place, and you will receive a list of what those restrictions are from probation and parole. Mr. Stosich may even have access to other sex offense treatment probation from maybe prior clients he had he could discuss with you. Does that make sense?
Okay, thank you, Your Honor.
All right, any other questions on your sentencing?
No.
Mr. Stahn, do you accept probation on those terms that I have outlined?
Yes, Your Honor.
And that will be the order of the court. Mr. Stahn, do you need time to make payments on these fines and fees?
meaning that.
Well, I've imposed a fine of $1,500, civil penalty of $1,500. Can you pay all of those today?
If need be, yes, I could.
I will give you time to make payments.
We would request a payment schedule. He has some financial ability, Your Honor, but I think it does have limitations, and since he's on probation for a period of time, there's no reason not to stretch that out.
Well, I agree with that. And the other reason that why we asked this, Mr. Stahn, is if you indicated to me that you would pay it today and then you realize you don't have the ability to pay it today, you could be in violation of probation right out of the gate. Not my intention. Starting in about 60 days, how much can you commit to pay each month? And you would then pay that amount monthly. And if you need to talk to Mr. Stosage, go ahead. Mr. Stahn?
$200 a month would be just fine.
We'll go just the end of February then, February 29. And then it will be the last, the 29th of each month from there that you would pay that amount. If you are able to pay more, then it gets paid off sooner. Anything else, Mr. Stosage?
Just wondered if the court intended on Mr. Stahn to be taken into custody today and get that calculation or
Yes.
report?
That
Okay.
was my intention, that you begin and serve that right now. And so we will have access to that calculation. All right? Anything else, Mr. Stosage?
Okay.
Mr. Thomason, anything else?
Nothing from the state.
All right, then with that, Mr. Stahn, I am going to remand you back to Bonneville County Sheriff to serve the remainder of that local incarceration, and then you'll be released to probation. I wish you luck on your probation. We're in recess. You are excused.
Thank you.